3, 2, 1.
This Honorable Court of Appeals is now in session.
Good morning to the attorneys.
Morning.
Morning, Your Honor.
I assume the appellant has already reserved any time for rebuttal at this point.
5 minutes, Your Honor.
Okay. We'll proceed in this action as if we were in court, except you won't have to stand up.
Thank you.
Present your argument as you're seated. Okay. Will there be more than one argument? I noticed that there are two attorneys.
Yes, Your Honor. For the appellees, there are two appellees, and the bonding company, Ms. Connell will argue, or Connell will argue for 12 minutes, and I'll argue for 3 on behalf of Ms. Nelson.
Okay then. Okay then. If there's nothing further, Madam Clerk, are there any preliminary matters we need to consider before we start?
No, Your Honor.
In that case, what you call the case?
Kim Renae Nelson versus Lorig E. Justice.
Oh.
For the appellant?
Yes, Your Honor. I'll begin, if that's okay, having to reserve 5 minutes for rebuttal. Loring Justice here. In the follow-up work to the classic Alice in Wonderland by Lewis Carroll, Through the Looking Glass, the character Humpty Dumpty utters a famous dictum: words mean whatever I want them to mean. Now, that's very funny and unique, and he begins speaking gibberish in that work. But in courts of law, and given the principle of equal justice under the law, even for an enemy of the state or someone we don't like, words don't mean what we want them to mean. They have an objective meaning. And the entire proceedings below were premised on the fact that filing a lien upon real property is not executing on real property. Now imagine if you were teaching a course and if you ask some student, is filing a lien on real property executing on real property? Imagine that student said no. They wouldn't do very well. And so the trial court seeks to have this court affirm an elaborate falsity that executing on real property is not execution, that filing a lien is not part of execution. And
Mr.
that's wrong
Justice,
for no other reason.
sorry to interrupt you, but that's an issue between you and Ms. Nelson, is it not? Not between you and the bonding company?
No, because it's derivative. No, obviously, there's a contract. So how could it be an issue? I can't see that being the case at all. By definition, it is an issue.
Because the contract that you have with the bonding company doesn't have any conditions on it. It's just a guarantee of payment. And so if Ms. Nelson did something that she shouldn't have or violated some stay, shouldn't that be between the two of you and not you and the bonding company?
No, and the reason is that the trial court's ruling below was that if it were execution, she would have violated the stay order, being in contempt, and that would have vitiated her the duty to pay. Obviously, because there would have been no consideration for the bonding company contract and voided it. So the whole order to pay, that the bonding company pay her, was premised on the fact that she did not execute. So the ruling below was that the bonding company will be able to claw back the money from her if this court determines execution to be execution, or filing a lien on real property execution. So, I mean, the problem is you have a contemptuous act, right? So the ruling in the trial court below originally was, oh, I'm making an attorney's fee award. Now that was, of course, made without any hearing or due process whatsoever, but it was made. And that was stayed, however. And it was stayed premised upon obtaining a stay bond. Obtain the stay bond via this bonding company. Then an order was put down of stay. Ms. Nelson violated the stay order, but of course the bonding company proceeds upon Ms. Nelson's order for the original attorney's fees. That's where they're getting their authority to be in the case. You can't distinguish between them. It's not impossible, but not rational or conceivable, since all rights are derived from the original attorney's fee award that was stayed, and she committed contempt of the stay order. And of course, that's not the position the appeal is in, because the trial court—
Wouldn't the contempt be decided by the court? Isn't that up to the court? If it's contempt of court, that's up to the court.
Up to the trial court, that's right. But we're saying objectively it is. I'm not asking that she be held in contempt or anything today, but I'm just calling it what it is. Let's just say the flagrant violation of a trial court order. But you're exactly right. I'm not asking for her to be held in contempt today.
Well, wouldn't even the trial court make that determination if its order has been violated?
The trial court should make that determination, but it is refused to. But then that's why this case should be remanded. It's exactly why it ought to be remanded.
Did you ever file a contempt charge with the trial court
No,
against
because
Ms.
that's the problem with this statute, is that I wasn't allowed any process. Remember, they didn't use Rule 65A, which is how you finish off a collection of a judgment. They used an 1801 statute 2 years before President Jefferson sold the Louisiana Territory or bought it from Napoleon. They used a statute that didn't allow for any process. So what they did is use I'm not lying, 1801 Tennessee statute that provides on bonds a summary award without any process. No hearing was ever held, no opportunity was ever given to do such a thing as you're speaking of, which might have been useful to this court. Essentially, what the trial court gave you was a results-oriented, slapped together thing that has produced a lot of these very reasonable questions that you're asking because there was no opportunity. And that's, we raised a constitutional appeal. We served the Attorney General on it that this 1801 statute was vitiated by Rule 65A. And of course, the Attorney General never responded. We did give them proper notice. I want this court to know that. But the old 1801 statute allows for no process whatsoever. So no opportunity to the things of which you're speaking. But, and just to reiterate on one thing, the rule specifically says, beyond any doubt, that filing a lien on real property is execution. And remember, the trial court pointed out, well, what do I do? Of course, trial court decided it wasn't execution, which is inexplicable. However, the other remaining point is that the trial court said, what do I do? There's not a lot of case law. Well, of course, there's not a lot of case law because I don't think folks routinely go around having the luck of getting a security for their attorney's fee award or other award, having that security, and then go violate the stay order. And let me point out, there's such bad faith here that the lien still remains today. Even though all parties, including the trial court below, said that it's no longer in effect, obviously, because there was a stay order. And now, of course, the bonding company has made payment. But the remedy should have been below that, of course, never got what I paid for, in the sense of I paid for a stay, paid for bond. It gave no effect. They executed anyway. Therefore, there was no consideration. She destroyed the consideration between the bonding company and I, and that vitiates contracts. If there's no consideration, a contract fails. And in this case, a third party was responsible for that failure of consideration by not only executing anyway, but executing and maintaining that execution on real property. And that is our seminal and key problem. I mean, there are numerous other problems with the appeal, not with the appeal, but with the result that should result in reversal on appeal. But that is the key one. And of course, the remedy would then be, as the trial court acknowledged, that the bonding company would then claw back that money from the appellee. That's the way it works. But it is beyond bad faith to maintain the lien till this day that has actually now been paid by the bonding company. And there's more bad faith to it. As they admit below, there was a fraudulent rate of interest used. They just made up some excessively large amount of interest. Now, the trial court did correct that after we pointed it out and did not allow, not the bonding company, but the individual appellee to fix that and use the statutory rate of interest. But that just goes to the level of malevolence involved. And there's no question that there was interest fraud. And there was other things that are very, very important that surely ought to be addressed. The trial court originally never approved the bond. So in one way, you could say it was never effective. The trial court was required to do it. It's unclear why that was done. In addition, or why it wasn't done, it makes not good sense. Of course, as we've said, the statute's unconstitutional in the modern era. You must allow some due process. By definition, the U.S. Supreme Court and the Tennessee Supreme Court and this court have said due process requires at a minimum in every instance notice and an opportunity to be heard. Nothing more. It doesn't go to substance, but it requires notice and an opportunity to be heard and present and cross-examine witnesses if there are matters involved. The 1801 statute that they used to get this quickie bonding approval of their judgment that they attempt to collect against me, that allows for no process whatsoever. So by definition, it has to violate due process because it allows for no process whatsoever. It simply assumes if there was a bond and then a judgment that there is some form of automatic payment. There are numerous other things. The original case was a manifest injustice under Rule 60. We filed that. The trial court refused to hear it. Of course, that's a known exception to the enforceability of judgments, which value the principle of finality very, very much. There's no question about that. But Rule 60 provides an escape valve, and courts have to hear it. So if someone raises one, it can't be completely dodged. That's wrong, and it hurts the law. But the court refused to hear the Rule 60 manifest injustice portion of our appeal too. There's no way to affirm this and respect the traditions of American and Tennessee law.
Thank you. You have your rebuttal of the appellee.
Thank you, Your Honor, and may it please the court. My name is Carol Lisa Connell, and I represent the Guarantee Company of North America with respect to this matter. In this matter, the trial court's ruling should be upheld for a number of reasons. First and foremost, the guarantee is entitled to a judgment under Tennessee Code Annotated 25-3-122. Second, Justice's various arguments against the enforceability of the statute are without merit. As a brief response to some of the issues that Mr. Justice raised in his argument, the bond is not conditioned upon whether or not Ms. Nelson did or did not execute on the judgment, or whether a stay was actually put in place. The consideration for the bond was that Mr. Justice paid the guarantee a premium, and the guarantee obligated itself to do something that otherwise it would not have been obligated to do, and that is to guarantee that Ms. Nelson was paid any amounts that she was due after appeal. Accordingly, whether or not the judgment lien is or is not proper, or whether that is execution, has no effect on whether the guarantee is entitled to a judgment against Mr. Justice. Despite the number of issues that have been raised by Mr. Justice in this matter, this case represents a relatively straightforward factual and legal issue. The guarantee's sole involvement in this case was as the bonding company on an appeal bond for a judgment that Ms. Nelson obtained against Mr. Justice in 2017. Mr. Justice appealed that decision and obtained a bond. The Court of Appeals denied his appeal. He then petitioned to the Tennessee Supreme Court, and that court also refused to hear the case. It was remanded back to the trial court, and Ms. Nelson made a demand on the bond. After receiving the demand, the guarantee requested that Mr. Justice fulfill his obligations relative to Ms. Nelson's judgment, and that he fulfill any obligations that he had for indemnity against the guarantee. Not only did Mr. Justice refuse, but he also objected to the guarantee's payment underneath the appeal bond to Ms. Nelson. Accordingly, and to ensure that Mr. Justice's objections were heard, the guarantee filed a motion to determine obligations under the appeal bond and enter judgment. The motion asked the court to determine whether or not Ms. Nelson was entitled to payment under the bond, and allowed Mr. Justice an opportunity to raise any issues or objections he may have that Ms. Nelson was not entitled to payment under the bond. In addition, the motion requested that in the event that the guarantee was held liable for amounts to Ms. Nelson under the bond, that it was issued a judgment against Mr. Justice pursuant to its indemnity obligations under Tennessee Code Annotated 25-3-122. The court heard all of the arguments that were fully briefed and raised in a full evidentiary hearing and determined that the guarantee was liable to Ms. Nelson and that the guarantee was entitled to a judgment against Mr. Justice for those amounts. The court also ordered in its order that the guarantee was to pay Ms. Nelson by a date certain, which the guarantee did. Pursuant to the plain language of Tennessee Code Annotated 25.3.122, the guarantee is entitled to a judgment against Mr. Justice. Section 122 very clearly provides that sureties are entitled to judgment by motion against their principals whenever the judgment is entered against them as sureties, whenever such judgment or any part of has been paid by the surety. It is undisputed in this action that a judgment was entered against the guarantee as a result of its suretyship of Mr. Justice, and that the surety paid that amount to the court that has now been sent to Ms. Nelson. Second, Justice's various arguments against the enforceability of Section 25.3.122 are without merit. Because Mr. Justice spent some time on the due process, I will start with that one and try to make my way through some of these. Under the federal and state constitutions, due process requires only that a party have the opportunity to be heard at a meaningful time and in a meaningful manner. The guarantee filed its motion to determine obligations and enter judgment on October the 29th, 2019. Justice filed a full written response to the guarantee's motion with respect to both Nelson's entitlement to bond proceeds and to the judgment against himself in the event that the guarantee was obligated to pay on January the 17th, 2020. Accordingly, Mr. Justice had approximately 2.5 months to consider the guarantee's motion, to conduct research, and to craft arguments in its favor. The court then held a full evidentiary hearing on January the 23rd, 2020, where it allowed Justice the opportunity to put on testimony, offer evidence, and make oral arguments in support of his position. While Mr. Justice counsel did argue orally, Mr. Justice did not attend the hearing and chose not to put on any evidence. On the other hand, the guarantee put on evidence of its loss, and Justice was offered the opportunity to cross-examine the guarantee's witness. This is the quintessential version of the opportunity to be heard in a meaningful time and in a meaningful manner. Mr. Justice has also raised a number of other issues, two of which in particular relate to preemption under federal jurisdiction statutes. Particularly, he has asserted that Tennessee Code 25.3.122 is preempted by the federal diversity jurisdiction statute and the federal interpleader statute. As a preliminary note, state courts and federal courts are courts of concurrent jurisdiction, and the United States Supreme Court has made clear that the mere grant of jurisdiction to a federal court does not operate to oust a state court jurisdiction over the same cause of action. The federal diversity statute and the interpleader statute neither have any indication that the federal court jurisdiction should be exclusive. Thus, they are not preempted. Additionally, neither of these statutes is relevant in this case. First, with respect to the diversity jurisdiction statute, it allows for federal jurisdiction over civil actions where their amount in controversy is over $25,000 or $75,000, and the citizens are of different states. While the guarantee acknowledges that those two requirements are met, the guarantee has the right to also file this matter in state court. In the event that the guarantee files this matter in state court, such as Roane County, Mr. Justice would not be permitted to remove this case under the removal statute because it expressly prohibits the removal of cases by what's known as home state defendants. Thus, because Mr. Justice is a citizen of the state of Tennessee, he would not be permitted to remove this case from the Tennessee State Court to the Tennessee Federal Court. With respect to the federal interpleader statute, it allows for jurisdiction over civil actions where two or more adverse claimants of diverse citizenship are claiming entitlement to the same money or property. In this instance, the only money or property at issue is the bond proceeds, and the only claimant to that money or property is Ms. Nelson. Thus, the fundamental requirement of the interpleader statute is not met. Additionally, even if Mr. Justice could make a claim that he was somehow an adverse claimant to meet the 2 or more adverse claimant requirement, the citizenship that is considered for jurisdiction in these cases is the citizenship of the claimants themselves. Mr. Justice is a citizen of the state of Tennessee. Ms. Nelson is also a citizen of the state of Tennessee, and therefore it fails to have diverse citizenship under that statute as well. Finally, Mr. Justice argues that Tennessee Rule of Civil Procedure 65A supersedes the Section 122 statute. Rule 65A provides a mechanism in which a party can obtain a judgment against a surety. It does not in any manner address the surety's rights against its principal. This court in Lacey versus Mitchell, and quoting the Tennessee Supreme Court in Thurman versus Mid-Cumberland Infectious Disease Consultants, stated that the court should aim to construe the statute in a reasonable manner that avoids statutory conflict and provides harmonious operations of the law. Because Rule 65A and Section 122 do not conflict or even discuss the same issue, the most natural and logical interpretation of Rule 65A allows for a judgment against a surety without the necessity of an independent action, and Section 122 allows for the surety to obtain a judgment against its principal by motion. The guarantee has found no case law or legislative guidance, and none has been cited by Mr. Justice that indicates any intent for Rule 65A to have superseded Section 122. In this case, the guarantee has provided Justice with an opportunity to argue to the court why Nelson was not entitled to any payment under the bond, despite no obligation to do so. To uphold Justice's position in this matter would be to undermine the whole purpose and rule related to appeals bonds, and would further put appeal bond sureties in the impossible situation of having to balance their bonded obligations with a judgment debtor's efforts to escape a judgment that has been fully adjudicated. There is no dispute that Mr. Justice had exhausted his appeals as to Ms. Nelson's judgment. For these reasons, this court should affirm the trial court's ruling and uphold the guaranteed judgment against Justice. Thank you.
Thank you. Okay. Yeah. We're ready for the.
Yes, Your Honor. I have 3 minutes, I believe.
Right here. Mhm.
This is
Right
Cecilia Peterson.
Go ahead, Ms. Peterson.
Cecilia Peterson for the appellee Kim Nelson. Very, very briefly, I took it upon myself to do the basic research. Mr. Justice indicated that the student who thought that placing a lien on property was not execution would fail the course. I submit he is incorrect. Ballantyne's Law Dictionary, 1931 version that sat on my grandfather's bench, makes it clear that there is a difference between execution and a lien. A lien is in fact part of the process. You record the judgment, and once it's recorded, it stays there inactive. The execution is the action. This is according to Ballantyne's. It's not Black's, but it's Ballantyne's. The actual execution is the delivery of the writ of execution to the sheriff for the sale of the property. That has never happened. There has never been an order of sale. All the levy does is say that should there eventually have been a sale subject to that execution, it overcomes any intervening obstacles, such as Mr. Justice's subsequent mortgages to himself on this property that the levy was placed against, the lien was placed against. There's been no execution. That's just basic. They call it black letter law. Let's call it Ballantyne's law. Furthermore, talk about bad faith and intellectual dishonesty. He kind of glossed over it in his argument, but Mr. Justice simultaneously says the bond was never approved by the court, so the stay was ineffective. So he's saying that Ms. Nelson has unclean hands because Mr. Justice didn't get the court to approve the bond. So she either violated a stay or she didn't. We say she didn't in any fashion because filing a lien is not the same thing as an execution, but he simultaneously says that the bond was ineffective to obtain a stay. So this is one where I know we can take alternate approaches for relief, but you kind of have to pick your poison when you get to the Court of Appeals and you've lost on appeal and you've lost at the trial level on the bond. And finally, let me say, because I don't see the clock and I don't know how much time I have.
Got a few seconds left.
He says the Attorney General was offered an opportunity to defend the constitutionality of this 1801 statute. The Attorney General was provided about 2 business days to make an appearance. If you notice, he sent out his response on the 17th and the hearing was on the 23rd with an intervening weekend in there. So I know that we've got an efficient state here, but that's not reasonable notice of your claim to the unconstitutionality. Thank you, Your Honor.
Thank you. Okay. Now we're prepared for the rebuttal.
Yes, Your Honor. My clock hasn't come up yet, but I could keep the 5 minutes myself, or maybe it'll come up in just a moment.
Right.
There it is. Thank you.
Okay.
A couple of things I would say that the folks on the appellee side got incorrect. The Attorney General time frame was a lot longer than that, and I think the record will show that, and I would entrust that to the record. But again, the Attorney General didn't object or say they had insufficient time. They just simply chose not to defend this 1801 statute. But let me be clear also with respect to what Mrs. Connell said about the hearing below. There was no notice given by the trial court of an evidentiary hearing and no evidentiary hearing on the enforceability of the bond and the propriety of enforcing the bond. No evidence on that. Yes, trial court allowed the bonding company to say, oh, this is how much interest we should have, or this is how much interest we should pay. As I mentioned before, Ms. Nelson used a fraudulent interest rate to try to jack up the award, and the bonding company put on evidence of the appropriate interest rate. But no opportunity, no evidence, nothing, and that's clear from the record, was given to stop the automatic judgment. This is how bad this 1801 statute is. And I'm not saying it's bad in the sense of those who passed it didn't have modern notions of due process, but literally in Newman versus Campbell, 1827, it allows for a judgment by motion in favor of the surety, even if the principal had no notice of the motion for judgment. Newman versus Campbell, 1827. It's completely inconsistent with our modern notions of due process. In addition,
do you have any up-to-date, so to speak, opinions or cases ruling otherwise?
Yeah, Major versus GMC, a federal case from the Middle District of Tennessee in 1990 wouldn't enforce that part of the statute. They allowed a hearing and required an independent action. So the only modern case to have addressed it, because what the court has smartly done, both the federal and the state courts, is you all have done Rule 65A that provides a due process opportunity. The only time it ever came up before in the modern era was in 1990 in Major versus GMC, and Judge Nixon, the late Judge Nixon, respectfully, just simply would not enforce the automatic judgment part and enforce the things to proceed as an independent action. But that's all you have in the modern era.
That's the federal district court, you mean?
The Middle District of Tennessee. It's 742 FSUP 1357, Judge, is the site for it. But more importantly,
now, is that decision in your brief?
It is on page 34.
Okay, then that's good. We'll see it then. Mm-hmm.
Yeah. And the most important thing about it is what I would respectfully recommend is simply take Rule 65A, which is what everybody uses now and has since the 1900s. But take Rule 65A and put it up against this statute. This statute they use, if you look at it, mirrors the first paragraph of Rule 65A, and then Rule 65A comes in and gives another paragraph that the original 1801 statute doesn't give. It gives people an opportunity to put on evidence. and to say, hey, there are reasons why this shouldn't be enforced as on an evidentiary basis. Now, it wouldn't make sense. Why would this court have passed a rule wholly duplicative of the 1801 statute, but adding to it, if not to provide procedures in Tennessee that were not available before under the statute? By definition, it means something was wrong with that statute. There's no other reasoning to it. And this sophisticated bonding company and sophisticated law firm that does work for the bonding company know that. You proceed under Rule 65A to enforce a bond or a judgment on a bond. That's what the Tennessee Rules of Civil Procedure provide for. None of the appellants challenge the assertion that even though there is a manifest injustice exception to the law of the case doctrine, and that you proceed under Rule 60 to fix that, including things like the improper conduct of the original trial judge, Don Ash, or numerous other matters like Ms. Nelson's duplicitous testimony about getting divorced from her husband, things that wouldn't change the result. There's a manifest injustice exception to the law of the case doctrine. You put that on through Rule 60. It wasn't allowed whatsoever, and no one challenged that. And that's not due process. No one's entitled to a result. Everyone is entitled to the process, and they ought to get it. And it wasn't given here. It wasn't given on the bond itself by short-circuiting it to that 1801 statute, and it surely wasn't given on the Rule 60 issue, and that is wrong. Thank you.
Okay, thank you. Thanks to the attorneys for their presentation. Your case has now been submitted to the Court of Appeals, and you will receive our opinion and ruling in a due course of time. Thank you very much. The lawyers may be excused.
Thank you.
Thank you.
This honorable court is in recess until 1:30 p.m.
And we'll go